humanly possible. After giving deep thought about how to handle this difficult situation, wherein demands of justice should be met, but at the same time the catastrophic effects on unity of federation may be averted, he conceived a device which he considered might salvage the situation, and I was chosen by him to play a role in the implementation of this device. He knew that my relations with Justice Dorab Patel, puisne judge of the court, were very cordial, and throughout the hearing of the case, I had not expressed myself in categoric terms or given any definite view on any aspect of the case. Indeed, journalists reporting the case had repeatedly written that my final views could not be deciphered. Consideration of provincial acrimony in the verdict, that is an extraneous consideration. This is an extraneous consideration that is admitted to by Justice Naseem Hassan Shah when he says that I went to negotiate on this platform.
This shows impression that the judges are deciding cases on the basis of their area, their provinces.
Yes, on basis of political considerations.
Is this not a bias?
Yes, that is the case. That is the case. Now, after this, sir...
Complainant belongs to which province?
Sorry?
Complainant belongs to which province?
Complainant belonged to Punjab as far as I know, sir.
No, you can't call it.
Now, sir, jahan tak interview ka sawal hai, there are a couple of things that I would point out.
Is it a confession? Is it an admission? Is it a correcting the historical record? What do you make of this memoir? What do you make of it? Your personal opinion?
These statements are admissions, prior admissions in writing, adverse to the interests of the person making them. If it was a court of trial even, these admissions could be admissible under Article 46(1) and 46(3), I think it is, of the Kanun-e-Shahadat. These are admissible statements. But over here, that is not the standard that your lordships are to apply. Your lordships are not sitting as a court of factual inquiry. Over here, the test that your lordships are to apply is, as a matter of law, is that what would a reasonable observer of judicial proceedings, what conclusion would he draw as to the safety of the proceedings after these revelations were made in front of him?
We go back to due process and fair trial.
Yes.
So this paragraph that you've read, 669 onwards, what do you draw from this? I mean, what's the conclusion?
जो 669 onwards है sir, उसमें ये है कि he admits that he was prepared, he was trying to change the verdict on the basis of considerations of provincial acrimony. That, with respect, is a non-judicial consideration. It is an extraneous consideration, and a judge cannot refer to these things while coming to a judgment and negotiating with a fellow judge.
Well, he was influenced from that the repercussion may be so that it cannot be controlled. Therefore, lesser punishment की तरफ हो जाना चाह रहे थे.
Yes, sir. बेशक, but it was not permissible.
वो तीन मान नहीं रहे थे और ये तीन
This is the dialogue that takes place between judges. That this is how one should do, or this will have this implication. Then they can settle somewhere else.
My lord, I have not had.
Yes, that's.
इसका disclosure किस हद तक करना चाहिए नहीं करना चाहिए ये तो percent vary करता है ना.
नहीं देखिए, I think this sort of dialogue at least hasn't ever happened with myself. What you, once it is ascertained, there are two aspects to a criminal trial: guilt or not guilt. And if there is guilt, then comes a punishment. How much? In matters of punishment, of course, you can discuss. Yes, this case is so horrendous, maximum punishment, or not really. It could be in a theft case. There are all these things have variations. You can see whether it's CNS, whether you have drugs. In matter of murder, there are only two punishments: life or death. So yes, but the negotiation aspect could be, or the discussion aspect could be on the part of either you try to persuade each other that their other person is guilty or not guilty. But the other negotiation can only be on the matter of the punishment part. And it's always, generally the settled rule is that even if one is inclined towards lesser punishment, you go with that view. I mean, I don't know, that's kind of, I think that's the approach. Even in bail matters, that if 3 judges, one thinks that's a bailable matter, then you go with that view rather than reject it by a majority. I don't know. I thought these are the principles we have evolved. What is your opinion?
Sir, जो Indian law में
नहीं, आपका opinion बताएं.
in my opinion, the verdict should be unanimous in case of death. If the verdict as to guilt is not unanimous, then death sentence should not be awarded because you can never bring back a life.
और ये जो डिस्कशन आपने पढ़ी है उससे भी यही लगता है कि सब उस पर शायद एग्री नहीं थे कि इट इज ए केस ऑफ कैपिटल सेंटेंस.
Sir, punishment के ऊपर permissible, technically speaking at least, and bowing to what Justice Mansoor Ali Shah has also said, but technically speaking, at least the only points of negotiation could have been how heinous was the case, whether what was the past track record of the accused, so and so, etc. Those were the only permissible judicial considerations. The political impact of it, strictly speaking, is a non-judicial consideration. It is an extraneous judicial consideration. I do, of course, although the traditional saying is let justice, let the justice be done, but the heaven, even though the heavens fall. But I do realize that sometimes practical considerations are discussed.
But I'm sure
just
you've read
pointing it out.
you've read books from American judges who talk about, you know, they go out for lunch together, they try to convince each other, you know, there's a lot of dialogue going on, they very openly write about it in
Yes,
their
sir.
books. So, and then it could settle elsewhere, it could settle somewhere else.
Fair enough, I'll move on to my next point, sir. The interview, sir. Sir, ये interview का अगर आप page 7, type page 7, interview is at tab 20. And इसका type page 7 जो है, that is $655. Itself is a little vague. I'll point out from the beginning. What it does say is that the relevant bit is middle of the page, Iftikhar Ahmed. Sir, ये भुट्टो का, जुल्फिकार अली भुट्टो का historical case है. मैं जर्नल
ये पेज कौन सा है?
655.
जी.
Jernal asar andaz हुए थे, that is Iftikhar Ahmed's question, and then Justice Shah answers, नहीं मेरा नहीं ख्याल असर अंदाज, हमें तो किसी ने नहीं कहा कि इस तरह फैसला करो, उस तरह फैसला ना करो, हो सकता है, and this is हो सकता है चीफ जस्टिस से वो बात करते हों और थोड़ा बहुत इनडायरेक्टली हमसे कहते हो कि इस तरह कर लिया जाए तो बेहतर है.
इसका क्या मतलब है? Indirect मतलब, हाँ?
This is, I'm just pointing out, I'm not...
What do you understand by it?
My lord, the implication is that nobody talked to me. They might have been talking to the Chief Justice who indirectly conveyed it to me. But that is an implication I'm not going to draw.
आगे भी पढ़ ले जरा.
जी सर.
लेकिन मैं 26 साल से ये भी पढ़ते हैं.
लेकिन मैं 26 साल सुपीरियर कोर्ट का जज रहा हूं. मुझे एक दफा भी याद नहीं कि कभी किसी ने हमें कहा हो फैसला इस तरह करो, इस तरह ना करो. ये जज जो हैं वो खुद ही डर जाते हैं कि हमने पता नहीं जमीनें ली हैं, जमीनें ली हुई हैं, हमारा बेटा मुलाजिम है, हमारा यानी अब कॉन्फर्मेशन का मसला आ रहा है, तो हमें फौजियों को नाराज नहीं करना चाहिए.
बाकियों के बारे में
जनरलाइज बात है, जनरलाइज
he's
बात
talking about the others, not himself.
हम क्या बात कर रहे हैं वो?
But he speaks specifically about the Chief Justice, at least in vague terms. But I'm not. The more important.
It is vague and you are referring next time इसकी commentary आप बना के.
Sir. सर दूसरा पेज जो इम्पोर्टेंट है, अगर आप पेज 8 टाइप पेज 8, दिस इज द नेक्स्ट पेज सर।
पेज क्या है?
सर पेज 656 और इसका अबाउट द 10th लाइन फ्रॉम द बॉटम। तो साहब ये जो जब मैं अगर मैं मुजरिम हूं, मैं अक्यूज्ड हूं, मैं कहूं कि मुझे आप पे एतबार नहीं, मुझे आपसे इंसाफ की तवक्को नहीं है, तो आप बतौर जज क्या करना चाहिए? नाउ इसमें फिर देन ही गोज डाउन द सेकंड लास्ट क्वेश्चन। इफ्तिखार अहमद, मौलवी मुश्ताक साहब की मैं बात कर रहा हूं। मौलवी मुश्ताक साहब को जुल्फिकार अली भुट्टो ने ये कहा। जस्टिस नसीम हसन शाह, जी हां, और मेरे ख्याल में मौलवी साहिब की ज्यादती थी, क्योंकि वो बहुत यानी जबरदस्त आदमी थे और वो भुट्टो के दुश्मन थे और उनको चाहिए था कि वो उस केस में ना बैठें तो बेहतर था। Now, if this was his view that Justice Maulvi Mushtaq was the enemy of Zulfikar Ali Bhutto, in that case again, while sitting on the bench in the Supreme Court, he should have come to a different conclusion.
ख्यालात का इजहार तो उनको अपने जजमेंट में करना चाहिए था, नोट कर लिखते उसको।
बिल्कुल।
लेकिन उन्होंने कहा कि जजेस जरा वो उस वजह से कुछ जरा की वजह से रह गए, नहीं कर रहे।
नेक्स्ट बिट सर, ये पेज 9 है, टाइप पेज 9 657 पे।
मिटिगेटिंग सर्कमस्टांसेस पे आर्ग्यूमेंट का भी लिखा हुआ है कि
जी जी उसका उस पे ही आ रहा हूं सर, मिटिगेटिंग सर्कमस्टांसेस पे आ रहा हूं। जी
कहां से पढ़ना?
जी सर, फ्रॉम द टॉप। सर आपने एक जगह पर अपनी राय का इजहार किया। आपने कहा कि भुट्टो के केस की समाअत के दौरान मेरी यानी आपकी जाती राय थी कि भुट्टो की सजा में कमी हो सकती है। जस्टिस नसीम हसन शाह, जी, और इस सिलसिले में उनका केस बड़ा मजबूत था। हाँ बिल्कुल, सो ही कंसीड्स दैट as far as that was concerned his case was very strong. फिर आगे सर इफ्तिखार अहमद आस, तो जज साहब जब आप कन्विंस थे जो आप फैसला दे रहे थे, तो डिसेंटिंग नोट नहीं आपको लिखना चाहिए था इस हद तक कि सजा ना दी जाए? जी हाँ, हो तो सकता था, मगर जब जो उनका वकील है वो कहता है मुझे सजा की कोई परवाह नहीं, मुझे तो एक्विटल चाहिए, तो चाहिए, मैं समझता हूं भुट्टो यानी जो है वो, सर आप भी डिसेंटिंग नोट तो दे सकते थे। जस्टिस नसीम हसन शाह, दे तो सकता था, मगर यानी मेरे ख्याल में इसमें कुछ थोड़ी सी हमारी भी कमजोरी थी और कुछ उसकी या बख्तियार की भी थी, यानी जिद, उसने हमें एक किस्म का नाराज कर दिया। Now, one, he is conceding to weakness in not dissenting. The second, he is attributing it to the annoyance created by the counsel for the accused. Now, obviously, that is something, and particularly in a death sentence case, whether the counsel of the accused is annoying or not, what he argues or what he does not argue, the judge has to apply the law and the facts on the record.
The litigant should not be punished because of conduct of
Exactly.
the lawyer. I mean, that's
Exactly.
basic, and even in every civil case, I mean, you may be faced with an obnoxious, let's say, counsel, but that doesn't mean that the litigant should suffer as a
And in
consequence.
a death sentence case, sir.
अगर वो
In
annoyed ना
any
होते,
case, I would
Yes, sir.
say.
In any case.
अगर वो annoyed ना होते तो ये दूसरी तरफ चले जाते और
शायद
कुछ और
उम्र कैद की सजा हो,
उम्र नहीं बल्कि acquittal
तो कह रहे हैं acquittal भी हो सकता था।
एक्विटल भी हो सकता।
लेकिन ये बात बिल्कुल गलत कह रहे हो कि उन्होंने आर्गू नहीं किया। ये 1979 की देखें 807 पे 174 पेज पे स्पेसिफिकली लिखा हुआ है कि ये मुख्तियार ने ये आर्गू किया कि ये मिटिगेटिंग का केस है।
कौन सा
Page 174, sir?
जी नहीं पेज है 807 पैरा 174
जी।
जरा पढ़िए उसको। अगर ये बात वो गलत लिख रहे हैं तो क्या गारंटी है कि जो कुछ बाकी कुछ फरमाया इन्होंने वो भी सही होगा?
ये कमिश्नर पिंडी वाली इंटरव्यू लग रही है।
उसमें देख लेते हैं
807 पे आइए ना।
Sir, does your lordship have the SCMR की citation या Supreme Court की? I have PLD 79,
PLD 79
Supreme Court 53.
सुप्रीम कोर्ट 807 पे आइए ना। 807 पे आइए।
Sir, ये मेरे पास, I'm sorry. जी, okay.
807 174 पढ़िए पहले।
जी, ये शायद ये रिव्यू वाली जजमेंट
हाँ, 174 पढ़िए ना।
174. We may now deal with the last submission made by Mr. Yahya Bakhtiyar that in any case, even if the conviction of the petitioner is maintained, it is a fit case where lesser penalty should be awarded for the offence falling under section 302 of the PPC, read with sections 109 and 111. Thereof, for the reasons that the petitioner is guilty only of abetment and was not present at the spot at the time of the murder, that the conspiracy was to kill Ahmad Raza Kasuri and not his father who was hit by accident, that the conviction of the petitioner is based on the evidence of approvers. There has arisen a difference of opinion between the learned judges of this court as to the petitioner's guilt, that with the introduction of Islamic laws in country with effect from 12th Rabiul Awwal, it would be anomalous to impose death penalty for unintentional murder, especially when Shariat laws do not recognize an approver, and the witnesses have to fulfill strict qualifications as to integrity and character before the testimony can be acted upon, and that the fact that the petitioner was compelled to boycott the proceedings in the trial has also a bearing on the question of sentence. Now, 175
जो कुछ भी यहिया मुख्तियार ने कहा, ये सेटल्ड प्रिंसिपल है मिटिगेशन के लिए, हमेशा कंसिडर किए जाते हैं फौजदारी लॉ में। कभी भी ऐसा हो तो हमेशा कंसिडर किए जाते हैं। तो ये तो थे, तो वो जो जैसा फरमा रहे हैं कि किसी ने आर्गू ही नहीं किया।
सर, अगर आप अगला पैरा पढ़ लें 175
पैरा 175 में
जी, we find that none of these questions was raised by the learned counsel during hearing of the appeal. Although all these factors,
he's not required to even.
कहाँ रिक्वायर्ड है यार?
सर, तो उन्होंने ड्यूरिंग द मेन अपील आर्ग्यू नहीं किया था, जिससे जजेस की तरफ से कुछ नाराजगी हुई।
वो पॉइंट तो रिव्यू में भी लिया जा सकता था, ये कोई ऐसा इश्यू नहीं था।
थोड़ी हमारी भी कमजोरी थी लिखा
ऐसा पनिशमेंट का तो इश्यू नहीं।
Now, my lord, the question was raised about the weight that is to be given to Justice Shah's revelations. I had already pointed out and it's the citations are also there, para 9 of my statement.
रिटायरमेंट के कितने दिनों बाद किताब लिखी थी उन्होंने?
ये 2000
Sir, 2002 में तो it is probably about 10 years.
This interview is
About 10
2003.
years. जी.
कितने
हमारे सारे लोगों को रिटायरमेंट के बाद इनका ज़मीर जागता है, वो कुछ कहना शुरू करते हैं। पहले तो कुछ नहीं कहते।
ये भी इधर
Sir,
अब इनके दो स्टेटमेंट्स आगे दो, एक तरफ जजमेंट है, दूसरी तरफ बुक है, तो किस पे रिलाई करें?
Sir, I am not saying that his book should also be relied upon. I am saying that his book has raised a reasonable possibility in the minds of a neutral observer.
To the extent that he condemns himself.
Yes, to the extent that he condemns himself, not anyone else. Now, jahan tak weightage to be attached to a book for these kind of statements is, my submission which I had made was that as per Article 46, 1 and 3, even in a trial, these would be admissible against Justice Shah. But in these proceedings, this court does not have to apply the standard of a trial. A somewhat similar situation arose, if your lordship will recall, in the dissolution of assembly cases. Over there, the question was that there were certain newspaper reports, etc., that was thought to be relied upon.
Which period are you talking about?
Sir, जो 90s के dissolution of assembly के cases थे. And lastly, in Benazir Bhutto versus Federation of Pakistan, PLD 1998, Supreme Court, page 388.
Gee, what was the point you're making?
The point that was, the distinction that was drawn there was that these newspaper reports are not being relied upon as per the absolute truth or otherwise of these reports, as would be done in a criminal
There's
case.
also a judgment that unless denied by the other party, these are the
जी
admissible.
बिल्कुल बिल्कुल उसमें डिस्टिंक्शन ये ड्रॉ की थी that over here we are merely gauging whether the president has reasonably formed his opinion under Article 58(2)(b), and the president is required only to he is not required to form an opinion on the basis of strictly proved evidence as required by law, but as a person of ordinary prudence would conclude. So if a person of ordinary prudence would conclude these newspaper reports which had gone unrebutted, that reliance could be placed upon them, so the president was justified in reaching that conclusion. Now over here, your lordship is required to put yourselves not in the place of a reasonable president, but a reasonable observer. And if the reasonable observer would use the book and the interview of Justice Shah to reach conclusions about the fairness of Justice Shah in the trial, in the appeal, then that is enough.
Render the opinion on this.
Yes.
We can discuss the conduct of Mr. Shah.
You keep on saying Justice Shah and it gets me worried.
Sorry, sir?
You keep on saying Justice Shah.
I'm sorry, sir.
I'm sure it was intentional.
No, I was very worried, sir. At one point, I had said Yahya Afridi instead of Yahya Bakhtiar, and I apologize for that also, I realized later.
I had missed that. Gee.
Now, sir, given that any opinion of this court,
Sorry to interrupt you. I'm seeing the original file, and this is the application of review filed by Mr. Hafiz Pirzada. I'll just read this paragraph. I don't know if he's made a mistake or it's so, that the remainder of the appeal bench comprised of 5 permanent judges of the Supreme Court, 1 ad hoc judge, namely Mr. Justice Wahiduddin Ahmed, appointed after his retirement under Article 182, and 2 judges of the High Court of Lahore, appointed temporarily on ad hoc basis under Article 182 of the Constitution. Who were the 2 Lahore ones?
Lord Justice Naseem Hassan Shah.
So they were temporarily from the Lahore High Court.
This is in the PLD.
PLD 78 सुप्रीम कोर्ट का जो है उसमें मेंशन नाम मेंशन किए हुए जजेस
मगर वो अडॉप्ट थे वो
अच्छा एक और पॉइंट जो which I have read, which I just want to read out, paragraph 9 from this application, that after the judgment was reserved, 2 developments of vital and grave import concern to the petitioner occurred. The first being that the Honorable Chief Justice was once again called upon to temporarily act as the President of Pakistan, and in that capacity delivered an address highly commending the bona fide and determined efforts of the present government to introduce Islamic order in the country, and in contradiction deprecated the failure in this regard of the previous governments. The remarks of the learned Chief Justice evoked a very strong protest from the leaders of the Pakistan People's Party and the wife of the petitioner, who by a letter dated 30th December 1978 requested the Honorable Chief Justice not to write the judgment and to dissociate himself from the appeal. But this aspect was not considered in the order that I have been able to see. These 2 points which have been taken in the review petition, rather the latter one, which the Chief Justice is commenting on very strongly on. I don't know if it has been or not.
sir, अगर आप Sorry, 1979 SCMR 271 देखेंगे
1979
SCMR 271
to show what?
सर उसमें एक ऑब्जेक्शन एक एप्लीकेशन फाइल की गई थी अगेंस्ट जस्टिस अनवारुल हक्स बायस वो रिजेक्ट की गई थी बट दिस डज नॉट डील विद द एस्पेक्ट दैट योर लॉर्डशिप हैज पॉइंटेड आउट
Who has decided the application?
Sir, this is by the full bench.
No, the author
Full
of the
court.
judge.
All 9 judges, sir, वो उसमें तस्करा नहीं है उसमें.
नहीं लिखा हुआ है
Anwar, sorry, just Chief Justice Anwarul Haq. Sorry, sir.
अच्छा
But it is an order of the court. There was a previous application that was also dismissed, जो बहुत detailed
नहीं,
थी.
ये जो जिस एप्लीकेशन का मैंने अभी जिक्र किया आपसे, this application, since you don't have the file, is 19th of February 1979, and this application that is being attended to in this order is 3rd of July 1978. So I presume it's some other
It
application.
is some other application.
So ठीक है, तो इसका कुछ पता है आपको क्या बना?
I do not know, sir.
About this fact that he became president of Pakistan?
I do not know. I don't. But I do know that he did
इनको
become
पता होगा
president
ना,
of Pakistan.
इत्सास साहब को जरूर पता होगा ना, या रजा रबानी साहब को पता होगा ये हिस्ट्री. Did he become president of Pakistan, the chief justice, acting president? Huh?
Several times, not just the one quoted here, because this was during the trial that he became, while he was earlier on, when the matter was before the High Court also. Mr. Justice Anwarul Haq, you can get the log, I am sure.
ये अगर आप ये जरा
acting chief justice.
रजा रबानी साहब को ये फाइल
सर
दे
ये
दें.
प्रेसिडेंट वाला मामला पहले भी उठा था.
ये उनको बोले 2 मार्क चीजें जरा पढ़ लें, मगर फाइल वापस जरूर ले लीजिएगा जी.
ये PLD 1978 सुप्रीम कोर्ट 125 में भी यही ऑब्जेक्शन उठाया गया था.
1978
सुप्रीम कोर्ट 125 ये इन चेंबर एक ऑब्जेक्शन की गई थी, वो उन्होंने अकेले सुन के उस पे फैसला किया था. इसमें अगर आप पेज 131
here it was a very standalone thing that as president you commented upon something.
जी
So how many objections were taken? 1, 2, 2 तो हमारे पास रिपोर्टेड हैं. और ये जो एप्लीकेशन का जो फैसला है रजा रबानी साहब, there are 2 tabs that I put. One is the application, 16R I think is the number, and the other one is the decision on that. But I didn't see this aspect of the case being attended to in that application. ये जरा देख लीजिएगा the Chief Justices, because at the moment we are only concerned with the prejudice of one of the learned judges, the ad hoc judge. But here is prejudice of the Chief Justice. These are up. Just have a look at these. Ji, sorry.
जी सर. So just pointing out कि ये
How long will you take?
I'm just wrapping up, sir.
Okay.
Now, given that the opinion of this court shall not disturb the finality of the judgment, and because with the proposal that I have put before your lordships, it will not have the effect of opening the floodgates either, because of the limited exercise your lordships will be doing. The question does arise whether just by giving an opinion, would it amount to basically an exercise in futility? Now, I would submit that it will not.
That is not for us to consider.
Malo.
If the president deems it fit to ask us a question, we'll answer it. Whether it's an exercise of futility or not, what difference it will make?
Bilkul. That is the.
Unless you are missing something.
That is the position. It is no one's case that someone wants to file a suit for malicious prosecution or proceed.
It's not an ordinary person. It's a president.
Yes.
It is a president, and he's been given a role in the constitution. Whether he should have or not, I mean, that's another debate. That's his domain. Ji.
Is there any material on the bias in law, the objective part, because this could also pass for a question of fact? this particular interviews and all this, but you're saying no because it's bias in law, this is a legal question.
Yes.
So any material to support that?
जी सर, वो मैंने in the note, the footnotes.
It's in the footnote?
जी, ये पेज 6 में जो footnotes हैं, उसके मैंने tabs भी बनाए हुए हैं. They deal with this. Now, finally, sir, as your Lordship, the Honorable Chief Justice has pointed out, right now your Lordships are confronted with only a reference. Now, the other underlying question, which perhaps in appropriate jurisdiction will need to be answered, is that how to balance a case of miscarriage of justice with finality of adjudication. How other courts have done it. Mr. Makhdoom Ali Khan had referred to Pinochet की judgment, जिसमें उन्होंने inherent jurisdiction invoke की. उसी तरह एक और judgment है जो मैंने cite की है, Taylor versus Lawrence. वहाँ United States में दो तरीके करते हैं courts. या तो एक वो quorum nobis की writ या दूसरा habeas corpus की. वहाँ उन्होंने habeas corpus को expand किया है कि they say कि it doesn't merely mean that before some FIR is shown, it also means that if someone has been unlawfully convicted and there is a fundamental miscarriage of justice, then using habeas corpus we can free them. Then there are of course the statutory remedies. I have detailed some of them in my note, where statutory bodies for review, and because often, sir, nowadays especially with DNA, new evidence comes to light which completely, and there is no scope. हमारे civil law में section 12(2) है, मगर equivalent counterpart criminal law में immediately nahi hai. So, but these are aspects for the parliament to consider, and perhaps in adjudicatory jurisdiction your lordship might see to what extent your lordship can deal with that. Over here an opinion would be sufficient.
CRPC 561A है वो
जी, वो 561A पे सर वो ये है कि आया उसको वो दोबारा खोल सकते हैं as a review exercise, उस पे debate है सर. So it is not clear.
Normally, Kaushman के लिए
It's been a pleasure hearing you, and you've been very thorough. And we'll certainly read your note and go through the points.
I'm grateful for the privilege, sir.
Let's conclude today's things, and tomorrow we will keep for, I think on the last date of hearing we had kept for yourself and Mr. Khalid Javed Khan, and both of you, Khalid Sahab, thank you for your assistance. And tomorrow we will hear the criminal aspect of it. Mr. Manzoor Malik and Mr. Asadullah Khan Chamkhani Sahab said he's already submitted a written brief, so if required we'll ask him questions. And tomorrow we'll start with Mr. Manzoor Malik. Ji.
I would like to address briefly on some aspects.
ठीक है. After Mr. Manzoor Malik, because आपने कहा you are not appearing, Mr. Raza Rabbani is appearing.
सर इसमें आपने I'm appearing for Bilawal साहब, आपने हमको जरा सुन ले, फिर इसके कहते हैं क्रिमिनल पर आइएगा. I would request that.
नहीं, काफी इस बात पे सुन लिया, जरा सा हम टोटलिटी भी देख लें. आपको डोंट वरी, आपको दूसरी बात का भी एंजाइटी है ना, वो फिर आप ये ना हो वही वाली बात हमारे साथ हो जाए.
नहीं.
So नहीं, इंशाल्लाह we'll try to again today we made ground. And we'll try to we will try to keep our questions and interruptions at a minimum.
There are certain videos which I would like that the court should hear.
We will certainly hear.
वो अभी तक आपने सुनी नहीं है.
We will certainly hear them. And if required tomorrow, कल हम चला भी लेंगे.
जी हाँ.
But let's this dimension has been thrashed enough. We wanted to now see the other dimension of the case, the total picture that emerges, and then you can maybe during the things, if it's relevant, we'll put it up. कल का इंतजाम कर लीजिए अगर वीडियो चलाने के.
कल ये सारी वीडियोस आप सुन लें, तो बड़ा क्या कहते हैं क्लैरिटी आ जाएगी आपकी.
उनके बाद देखें वो आ रहे हैं तो जरा उनको खत्म कर लें, फिर आप
चले उनके बाद फिर हमें क्या मंजूर मलिक साहब के बाद
we will just see how it goes. I don't know, कल एतजाज साहब को भी सुन लेंगे. अगर सिर्फ बता दीजिए आप किसको रिप्रेजेंट कर रहे हैं.
I was appointed amicus on the.
Why have you not been coming?
सर मैं
खत्म नहीं कर दिया सर।
आप आए नहीं पहले
वाली लिस्ट में थे ना जो ओरिजिनल।
चले खैर। आपको कोई इतराज है? बट आई डोंट नो किसी को, बिकॉज हम देखें इतराज साहब हमने लास्ट टाइम कुछ लोग अमाइकस पे इतराज था, हम लोगों ने उनको नहीं रखा। अगर इफ एनीबडी हैज एनी ऑब्जेक्शन से सो, अदरवाइज वील हियर मिस्टर।
There was a statement made regarding you that इसने कोई से ऑर्डर शीट में लिखा है। ऑर्डर शीट जूनियर पेश हुए थे मेरा ख्याल है।
What was the statement?
We'll just there's a order sheet. Let's have a look. जी पहले वो ऑर्डर
ये था कि इन्होंने कोई रिप्रेजेंट कर लिया
नहीं इनका नहीं था, इनको जूनियर पेश हुए का उन्होंने
because your name was mentioned on that day.
2-3 ऑर्डर दिए हैं, ऑर्डर शीट देख लो। वो एक मिसपरसेप्शन थी कि आई वाज इन द
Somebody made a statement at the bar.
interim that is right. In the interim I was instructed by the president, Mr. Zardari, and since Mr. Naik and the Attorney General
No, I had nothing to do with the president. I filed an impleadment application on behalf of Bilawal Bhutto Zardari. I had nothing to do with the president of Pakistan.
यह सबकी बात मुझे भी कुछ याद आ रहा है, ऐसी बात हुई थी।
कल देख लेंगे।
and I thought it, I want to clear this.
We'll do it tomorrow. So देख के फिर कल कर।
ऐसा करें, आप जरा ऑर्डर शीट देख लीजिए।
जी सर।
अगर कोई ऐसी बात ना हुई और अगर
शीट
क्लैरिफिकेशन
में नहीं है सर।
बस फिर ठीक है।
फिर हम देखते हैं कल।
ऑर्डर शीट
चलें, थैंक यू वेरी मच। टुमारो सेम टाइम 11:30 आज का लिख दें, और शॉर्ट ऑर्डर है। लर्नेड MIC Mr. Khalid Javed Khan and Mr. Salahuddin Ahmed have concluded their submissions. They have respectively filed CMA number so and so to come up tomorrow at 11:30 a.m. ठीक है।
लोकतंत्र की परिकल्पना सबसे पहले भारत भूमि पर ही साकार हुई थी। लोकतंत्र में सरकारें चुनने का अधिकार केवल जनता का होता है और भारत के लोकतंत्र का जो दुनिया में विशेष स्थान है, उसकी ये पहचान और लोकतंत्र की शान दुनिया को चमत्कृत करती रहती है। इसी कड़ी में महत्वपूर्ण अध्याय तब जुड़ा जब पिछले वर्ष देश की 15वीं राष्ट्रपति श्रीमती द्रौपदी मुर्मू ने सर्वोच्च संवैधानिक पद पर अपना कार्यभार संभाला।
दुनिया के सबसे बड़े लोकतंत्र भारत में पहली बार एक आदिवासी महिला ने राष्ट्रपति का पदभार संभाला है। देश के सबसे पिछड़े इलाकों में शुमार ओडिशा के मयूरभंज जिले के संथाल परिवार में जन्मी द्रौपदी मुर्मू का राष्ट्रपति पद तक का सफर उनके संघर्ष की कहानी बताता है। अभाव में गुजरा बचपन, युवा काल का संघर्ष, व्यक्तिगत जीवन के उतार चढ़ाव, सार्वजनिक जीवन की सादगी और बेदाग छवि, यही है बहुआयामी प्रतिभा की धनी द्रौपदी मुर्मू का व्यक्तित्व। साल 1979 में भुवनेश्वर के रामा देवी महिला कॉलेज से स्नातक करने के बाद आपने ओडिशा सरकार के सिंचाई विभाग में क्लर्क की नौकरी की। कुछ समय बाद नौकरी छोड़कर आपने अपने घर रायरंगपुर में एक शिक्षक के तौर पर भी काम किया। एक शिक्षक के तौर पर अपने क्षेत्र में उन्हें एक नई पहचान मिली।
जाके क्या बनना चाहती हो? टीचर। वाह, वेरी गुड। टीचर मतलब क्या होता है जानती हो? देश को बनाने वाला, IAS ऑफिसर को बनाने वाला, IPS को बनाने वाला, इंजीनियर को बनाने वाला। टीचर जो होते हैं वो बनाने वाला होते हैं, इसलिए टीचर सदा नमस्य होते हैं।
इस तरह जनता और समाज से जुड़कर लोगों के बीच एक अलग पहचान बनाई। साल 1997 में द्रौपदी मुर्मू पहली बार रायरंगपुर नगर पंचायत में वार्ड पार्षद बनी। इसके बाद वो नगर पंचायत की उपाध्यक्ष भी बनाई गई। पहली बार विधायक बनने के बाद आपने साल 2000 से 2004 तक ओडिशा सरकार में स्वतंत्र प्रभार राज्य मंत्री के तौर पर काम किया। आपको ओडिशा में सर्वश्रेष्ठ विधायकों को मिलने वाले नीलकंठ पुरस्कार से भी नवाजा गया। इसके बाद साल 2015 में आपको झारखंड का राज्यपाल बनाया गया। सार्वजनिक जीवन से लेकर संवैधानिक पदों पर दशकों से रहते हुए श्रीमती द्रौपदी मुर्मू की छवि बेदाग रही है। सन 1958 में जन्मी द्रौपदी मुर्मू पहली राष्ट्रपति हैं जिनका जन्म आजादी के बाद हुआ।
महिलाओं के विकास में ही देश का विकास निहित है। महिलाओं के योगदान से निकट भविष्य में ही भारत एक विकसित राष्ट्र के रूप में उभरेगा। जय हिंद, जय भारत।
जहां आपका राष्ट्रपति बनना